We'll see you back in 3 weeks. Y'all can talk about it then. You're at, ma'am,
What?
this is not gonna help.
Don't matter, my life's on it.
Well, looks like you did that, not me. I'll see you in 3 weeks. Which, come on, hold on, get her, don't let her go. Come back.
What?
Everybody heard it.
You said you're bullshit.
Come back.
Sure, lawyer.
I told my lawyer he was bullshit. I didn't say this.
You don't talk like that to anybody in this case because he didn't do this either, you did.
She walked into that courtroom convinced she had worked out a favorable deal, just 4 years of deferred probation for a theft charge. At first glance, it looked like she might actually pull it off. But the moment Judge West opened her file and started reading line by line, the entire situation unraveled like a house of cards. Her record was staggering: 14 felony charges, 5 misdemeanors. And to top it off, she was already serving probation for a separate and serious matter. With a history that heavy, the idea of walking away with probation was never going to stand. The agreement didn't simply fall apart. It completely disintegrated. Once the judge made it clear the deal was off the table, her reaction sent the courtroom spiraling into disorder. What was supposed to be a routine hearing suddenly turned into a scene filled with tension and disruption. The outburst was dramatic, but what stood out even more was the sheer risk she was taking. Watching her push back in that moment felt like watching someone play with fire in the most reckless way possible. And that leaves a big question. Was this a case of someone believing they were untouchable, or was it a bold act of defiance against a system she thought she could outsmart? Either way, the outcome was nothing short of explosive. Let's break it down.
Good morning. Good morning. Are you Crystal Vogan? And Ms. Vogan was previously in court, entered a plea of guilty to theft of property, a state jail felony. That agreement was for a 4-year deferred probation with a $1,000 fine as well as restitution in the amount of $9,400. I've received the pre-sentence report. Have y'all all had an opportunity to review that report?
Yes. Yeah.
And any additions or corrections or?
There's a lot of history, we understand, Your Honor, but discussed it with counsel also about restitution.
Speak up, I'm
I
sorry.
just want to make sure the court knows restitution, most of the main issue we're looking at, get some of that money back.
I've got 1, 2, 3 and a quarter pages of criminal history. Well, there's a lot of stuff that wasn't. There were 14 felonies that weren't dismissed. At least 4 or 5 misdemeanors that weren't dismissed. I understand the restitution, and y'all know my position on that already this morning, but there's I mean, she's on probation right now in Sutton County, correct?
Yes.
I have been for 2 years.
Right. So do they know about this case? And what has happened over there, if anything?
I'm still continuing on my deferred. Because I'm actually supposed to start nursing.
I can't understand you.
I'm supposed to start nursing school.
When?
I was actually supposed to start in September, but I had to wait to see.
Are you really going to be able to go to nursing
Yes, I
school
am.
with this type of criminal
Yes, ma'am.
history?
Yes, deferred. Yes, ma'am.
Another issue that I see on here also is the restitution, because it shows 9,400, but then it also, that was from inside the bank, and then it shows 500 from an ATM and 100 from a cash app, totaling 10,000, not 9,400. Is that correct?
And that would have been added on, Your Honor, that's a bank fee, I believe. I don't think that.
Well, it says 500 was withdrawn from an ATM outside the bank. Is that right? You know better than anybody.
I only went into it. I didn't have no access to the card.
Okay. So possibly the other person that was involved did that?
The only thing we knew about
That
was
was
the
no-
9,400 that was within the bank.
I wasn't aware of it, Your Honor, when we did it, when I got the PSIs, when I was notified, I was in the cash app. But if it was a withdrawal, then that would be her responsibility joint and separately, so.
Right, it says, so
Just a request.
the contact from Do Good said that the defendant withdrew the entire loan amount of $10,000, 94 from inside the bank, 500 from an ATM, and 100 from a Cash App transaction. It doesn't matter if you did it or if the other person that you were with did it. Y'all were working together. So you're both, and what's the other status of the,
I don't have the other status of another person, Your Honor. This is one who has the charge. I'm not coaching on there. But she's responsible.
yeah. So I mean, if there was another person, and you didn't give that
I
information,
don't
then
know.
that's, okay. Apparently the cops didn't either, so.
She went in the bank, she was the one called. Side, whether or not she had a conference call. The backside is not, to my knowledge.
And hold on, so the probations in Sutton County, have they been transferred to Harris County? So you're going in person in Harris County?
Yes, ma'am.
Okay, and so it's the state's position to go forward with the agreement?
I understand the court's concern, and the state has the same. Like I said, our initial deal was to get some of the money back on our victim, however, we
So,
understand.
all right, so here's what I'm gonna do, Ms. Bogan. I'm going to find that you entered your plea of guilty freely and voluntarily. Can y'all hold it down over there, please?
Let's be honest. Her plan didn't just sound ambitious. It sounded completely unrealistic. She stood there talking about her dreams of going into nursing, but when you line that up against a record carrying 14 felonies and other serious charges, it simply doesn't add up. Think about it. Would anyone really feel comfortable trusting their health to someone with that kind of background? It's a hard no. Judge West didn't even have to go on a long search through the case file. Right away, she spotted one of the biggest issues, a theft involving $10,000. And here's the thing. The defendant tried to downplay it as if the amount was closer to $9,400. But the judge wasn't buying it. The evidence showed every detail. The withdrawals, the ATM usage, the digital transfers. This wasn't a one-time mistake. It was carried out with accuracy, almost like a blueprint. That's what makes a situation so striking. Nursing is one of the few professions built almost entirely on trust and responsibility. Patients hand over their well-being, sometimes their very lives, to those who wear that uniform. And here's someone asking for that role while carrying a history of financial manipulation. The contrast couldn't be sharper. The irony hit especially hard in the courtroom. Instead of stethoscopes and patient charts, people were scrambling over ledgers, numbers, and withdrawal receipts. It felt less like a career pitch and more like a financial investigation. And at the end of the day, if this is a path she's determined to walk, it seems clear her future uniform is far less likely to come with medical scrubs and far more likely to include handcuffs.
I'm gonna find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. I just don't know. I just can't believe I'm even considering doing this, honestly. I'm not. I can't. There's no way. It has to be straight probation, and I realize that that's gonna potentially have some issues, but I can't with 14 prior felony offenses, same type of thing, so.
I don't.
You do,
No, I don't. No, I don't.
okay? How many do you think you have?
I have 3 here and one back home.
Okay, you have lots of them that were at the same time for different offenses.
And I was never convicted, never charged.
Yeah, you did probations for them. Forgery of a financial instrument. Don't talk over me. March 3rd, 2008, Harris County, 180 days in jail, so that one was reduced. March of 2014, forging identification cards in Cuyahoga County, Ohio, 1 year probation. Same charge, same probation, so that's 2 in Ohio. March of 2014, theft, aggravated theft in Ohio, another probation, the same date, but still another charge. March of 2014, attempted drug possession, pled guilty, 1 year probation. March of 2014, same thing in Ohio, possessing criminal tools, probation, all that. It was at the same time, but still different cases. November of 2014, forgery, 2 cases, got probations in those. I'm gonna run out of fingers. March, another one, a theft, aggravated theft in Ohio in 2014. Then we go to Sutton County, Texas, and you have 1, 2, 3, 4, 5 continuous smuggling of persons for pecuniary benefit, and that's the 10-year probation that you're on in 5 different cases.
Okay.
That's not correct.
No. Okay.
So how many cases are you on probation for in Sutton County?
It all ran together.
I understand it all.
It's one.
It doesn't run, but that's not how it works.
Yes, ma'am. Yes, ma'am.
When it runs together, it just means you're serving it at this. I'm rejecting the plea agreement. I'm resetting your case for 3 weeks. We'll see you back in 3 weeks. Y'all can talk about it then. You're at, ma'am,
What?
this is not gonna help.
Don't matter. My light's on anyway.
Well, looks like you did that, not me. I'll see you in 3 weeks. Which, come on, hold on, get her, don't let her go. Come back. Everybody heard it.
You're bullshit.
Come back.
You're a lawyer.
I told my lawyer he was bullshit. I didn't say this.
You don't talk like that to anybody in this case because he didn't do this either, you did.
He got me the plea.
He did get you, he did a great job. I'm gonna find at this time that your bond is not sufficient because of your attitude and because of your criminal, because of your,
I gotta go to work. So I'm gonna lose my job and everything too.
Well,
Please,
maybe
Mom.
you shouldn't cuss at your lawyer. Maybe you shouldn't have this attitude here in the courtroom. I'm going to raise your bond. What's the bond currently set at? Don't cry now after saying it's bullshit to him and acting like this in here. Stop. No, you're going to make it worse. You're just going to make it worse. You should, when I told you a minute ago to stop, you should have stopped when I told you to. All right, I'm going to set your bond at $25,000. Go back with the bailiff.
The moment her plea was denied, her reaction was immediate and impossible to miss. She folded her arms, stormed off with visible frustration, and then turned on her attorney as if he were the reason everything crumbled. But let's be clear, this wasn't about a missed detail or a bad defense strategy. This was about a record stacked with 14 felony charges and years of repeated run-ins with the law. That's not a simple mistake. That's a pattern. Blaming her lawyer in that moment didn't change the reality staring her down. Every time she stepped into that courtroom in the past, it was another roll of the dice, and sooner or later, those chances were going to run out. This wasn't sabotage from her defense. It was self-sabotage played out over years of choices that ignored consequences, and then came the comment, "My life is over anyway." That wasn't a tragic revelation. It was more like reality finally catching up. Sympathy becomes hard to summon when accountability has been dodged for so long. What stood out most was how quickly the blame shifted away from her actions and onto everyone else, as though the system should carry the guilt instead of the person who built the record. That's the bigger picture here. It reveals just how distorted accountability can look when someone acts as though rules don't apply to them. The truth is, this wasn't a deal ruined by a lawyer or by a tough judge. This was a deal ruined by a long history of choices finally stacking too high to ignore it. So the real question is this: should there be any leniency for someone who had consistently tested the system, or is this outcome exact to the one she wrote for herself?
Let's see how today goes. Ms. Bogan, when you were here yesterday for sentencing in cause number 25 DCCR 0026, just so the record's clear, I rejected that agreement based on your criminal history. The fact that it was a deferred probation, I feel like with your criminal history, it is at this point, if you're going to accept responsibility, time for a conviction. You were going to be able to leave yesterday. There was an incident in the courtroom. Based on all of that, I raised your bond. Mr. Lewis asked that we bring you out today. Mr. Lewis, what is,
Well, Judge, yesterday afternoon, I went and spoke with Ms. Bogan about everything going on with the case. One, she did apologize to me, and she said, of course, when she had the opportunity, she wanted to apologize to you, to the court, for her actions yesterday. I did explain to her as far as where we were as the case, the rejection was there on the deferred. You did kind of put at that point, it would have to be a straight probation with the restitution if she was to be on any type of probation. She told me she was more than willing to accept that. She understands how it may affect her with her job, but if she wanted to still, if that opportunity was there, she wanted to definitely take it.
Mr. Hoffpower?
Judge, in light of all that the court's already mentioned and cited, we're gonna leave it to the court, but we would not be inclined to put her on probation after the way she acted and due to her criminal history, so we would,
Well,
if the court wants to allow her to do straight, that's fine, I understand.
yeah, well, that's what your argument was yesterday.
It was.
To continue, for me to go forward. So, I mean,
Two quick-
the most important thing to me, obviously, I don't know that you deserve a probation at all with your criminal history. But as I said yesterday and today, it is time for you to have some responsibility and some consequences for continuing to commit felony offenses. You know, it's great that you can finish a deferred probation, but at some point, you got to quit getting felony offenses and quit violating the law. And so I don't think that's fair at all. So what I can do, I have the paperwork still from yesterday. And if you guys would want to agree to a convicted probation, I can make that modification on this punishment recommendation. And then I can kind of reinstate everything up to the plea and all of that, so we don't have to go through all of that. So I'll reinstate everything we've done prior to today, make that modification on the paperwork, and go forward with sentencing. Is that everyone's agreement?
That's fine, Mr. Judge.
That's fine with us.
The modification will be a 2/5. It will be a 5-year probation. It will be a convicted 2/5. I am going to, I'm not inclined to order a fine because I want that restitution paid. So I'm going to mark through that. So with everyone's permission, I'll make that change. And that's what everyone's agreement is. Is that correct? And it's I want to make sure you understand that this is now your agreement. And so if I follow an agreement to give you 2 years in the state jail, but probate it for 5 years, order that restitution, you can't change your mind later. This is your agreement. Is that correct? Okay. And the restitution will be that 10,000. And that's everyone's agreement as well, correct?
Yes, correct.
All right, then at this time, Ms. Vogan, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft of property. Sentence you in accordance with your new agreement to a term of 2 years in the state jail prison, but I'm going to probate that. You'll be on probation for 5 years. You're ordered to pay the $10,000 fine, restitution, and to follow all of the rules and conditions of probation. If you do this, this is still a good opportunity because you will be able to serve that 2-year sentence while you're out on probation instead of in the state jail prison. The other side of that, though, is if you violate any condition of probation at all, you will be brought back into court and you will be facing that 2-year sentence that I just gave you. Do you understand? I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. Good luck to you, ma'am. Do you need my PSI? I printed it out. Okay, you've got everything. I'm sorry, I just printed my PSI, but y'all can throw that away.
Orders, but I have them.
You have them? Okay.
Judge, if it's okay with the court as well, we do want to apologize to you.
Yes, ma'am.
I'm very, very sorry. I was going through a lot, which I understand and understood. And and I do apologize for my actions and behavior.
I appreciate that. Make sure that while you're on probation, that you don't let those emotions also get in the way of you being cordial and doing what you're supposed to on this probation as well as the other one that you're on, because that just in itself could get you right back in here. Even if you disagree with whatever they're ordering, whatever, if you disagree, you disagree, but you have to do everything they said and you have to be cordial. Thank you for your apology. You can go back with the bailiff.
I couldn't help but notice the irony in her outfit choices. One day she's wearing nursing scrubs, painting a picture of a future where she's saving lives and caring for patients. The very next day, she shows up in a crisp button-up shirt, the kind of look you'd expect from someone chasing a job interview. The problem is, there isn't an interview, and there certainly isn't a career waiting. That switch alone spoke volumes. The dream had already collapsed, and reality finally delivered the news. But the bigger issue here goes beyond her wardrobe. This case highlights exactly why probation has become such a controversial topic. Think about it. 14 convictions on record, a $10,000 theft under her belt, and yet probation still lands in her lap as though it's some kind of reward for showing up. At what point do we stop calling it rehabilitation and admit it's closer to supervised babysitting? Probation was never designed for repeat offenders. Historically, it was created back in the 19th century in places like Boston as a way to give first-time offenders a chance to prove they could stay out of trouble. That was the original intent. But this isn't 1878, and she's far from a first-timer. When someone with that many convictions is still being offered probation, it doesn't just stretch the system. It weakens the trust people have in it every time the rules bend this far. It chips away at the credibility of probation itself. And the sad part? It also overshadows the people who truly deserve a second chance, the ones who could actually use probation as a way to rebuild their lives. Instead, it starts to look more like a revolving door than a real tool of justice. So here's a question. Are we still using probation the way it was intended? Or has it turned into a free pass for people who have already burned through every chance the system could give?